do want to make sure that all of our board members have the resources that they need in order to best lead their communities. So this is going to be a question and answer format. And if you have the option of submitting questions right in the chat box. If you do submit a question into the chat box, I'm going to serve them up either if they're contextually appropriate to that particular part of the conversation, or we're going to save them until the end. So for those of you who have not met tonight's attorney, you're in for a treat. David Firmin is joining us, and he is a Colorado attorney, which is helpful. He graduated from the University of Denver School of Law in 1998. He's a longtime resident of Colorado with over 15 years of experience that has given him a strong background in representing community associations, from everything from development to operations to dissolution and everything in between. He is the managing partner, or is a managing partner, of Altitude Community Law. Before we do jump into this, I also want to make the comment that the information presented on this call, it's not interpreted as legal advice to your association. Associations, they vary greatly, and legal opinions should be solicited from your association's attorney to fully consider all the context of your community and the community's governing documents. So with that, let's get started. Worth, why don't you start off with some of the questions that we had already submitted?
Good afternoon, David. Great to see you again, even if it's online. You might not be surprised, but our first question begins with money. So assessments are typically the only form of income for an association, and failure to collect assessments, even during challenging times like today, put associations in a shortfall situation. What options are most important for boards to consider when it comes to collections and expense management?
Well, it is a very good question, a very poignant question, due to the fact that when an association goes into a budget year, it is required, pursuant to the Colorado Common Interest Ownership Act at least, to budget to its anticipated cash needs, meaning that if you have X number of expenses, you're budgeting to that X number of dollars. Therefore, you can't waive, or you really do need those dollars coming into the community. So when you're looking at how can you manage the cash flow during a time like this, are you going to have certain expenses that you may be able to trim? Yeah, you might. Particularly with not opening common elements, that, you know, if you had a pool, you probably can put that off opening. If you have certain other items that you might be able to put off, you can find savings there. But as far as the assessments go, an association is not permitted to forgive assessments, and it's not permitted to go in and say, "Nah, you don't have to pay your monthly assessment," because again, you still have maintenance costs, you still have insurance costs, those bills aren't going away. If it's commonly metered water, you still have water bills that aren't going away. And if you miss your insurance payment while utilities have been told don't do shutoffs, insurance companies certainly have not been told not to cancel policies for failure to pay. So you still need to make sure you meet those expenses. CAI, the Community Association Institute, came out with a plan for compassionate collections, which you can absolutely go down that path of compassionate collections, understanding, working around, maybe extending some payment plans, forgiving late fees, penalties, interest. But at the same time, that principal has to be due. And you need to make sure that as soon as possible, if consistently getting that money in the account. We've had associations look at borrowing from their reserves. And if you're going to borrow from your reserves to cover these potential shortfalls that you may have, short-term shortfalls, make sure you document that borrowing from the reserves. You have to pay yourself a competitive interest rate. That money was in reserves, it's in a savings account. If you just take it out and use it for operating, that becomes a taxable event. And the IRS frowns upon you taxing or taking those monies. It's commingling of funds. You have taken something for long-term capital, used it for operating. And as such, that money needs to be paid back. And in doing it, I highly recommend you go ahead and document any of that savings or document any of that borrowing.
Thank you, thank you. Next question. Over the last few weeks, we've experienced significant changes in the way we manage and operate community associations. From a legal standpoint, what authority does a board have when it comes to permitting guests or service workers or contractors to access an owner's unit and common areas? And what requirements, if any, can we enforce when it relates to personal protection equipment?
And again, a very, what is becoming, I will say, very common questions. Had a number of associations call up and say, can we prohibit renovations? Can we stop people from bringing contractors into the community and the like? So kind of taking this, parsing this down. One, an association cannot prohibit an owner from using, I will say, general common elements to the extent they access the unit, coming into the lobby, going in the elevator, going up the elevator. Can the association absolutely prohibit use of the recreation amenities? Yeah, you can. You can close the pool, you can close the clubhouse, you can close any picnic areas or any picnic tables. If you look at the current stay-at-home order in the state of Colorado, it prohibits public gatherings. One, it states stay in your residence, and to the extent you can't stay in your residence, you are supposed to go to and from directly your destination to get medicine, to get food, to apparently go to the liquor store, which is deemed essential in the state of Colorado as well. But that's neither here nor there. It also prohibits gatherings outside of the units. So you can't have a gathering of more than 10 people. In the city and county of Denver, it's a little bit even more. Mayor Hancock came out with his restrictions and says you can't even share recreation equipment anymore. You can't kick a soccer ball to your son or your daughter. You can't throw a frisbee to somebody that lives in your unit. That's how the city is breaking down, and it gets to the fact that, like I said, are you at least mandated to keep these areas closed? Yes, you are. As far as bringing contractors into the community, you need to make sure that any contractor that you're bringing into the community is performing an essential service. The state has stated that some services, even though they fall under construction, are not essential. If it's painting, if it's aesthetic, that's not essential work. Plumbing, electrical, roofing, that's essential work. So you need to make sure that your contractors are coming in and abiding by the social distancing that's required by the state as well. Whatever your state may be, you need to make sure that, again, these are kept and workers are kept 6 feet apart. You need to write into any contracts that you're doing to make sure that they stay it and they're not flooding the community. But like I said, as far as the unit owners, you can't necessarily prohibit them from having guests come in, but you can prohibit where they go and the amount of people that can come in or ride in an elevator. You can reduce your elevator capacity to 2 to make sure that you're maintaining that social distancing.
Great, thank you. Well, whenever we encounter events such as a natural disaster, storms, and in this case, a pandemic, I know that there is potential for lawsuits after the fact. When this happens, we often look back and we ask ourselves, what could we have done differently to mitigate that risk? So if we look forward, what steps can association take today to identify those risks and try to mitigate those through best practices with management and, of course, our insurance?
I think part of that question is, I'm hearing rumblings of owners threatening lawsuits for not opening the common elements. We pay for these common elements. We need these amenities. I know of a situation where somebody is trying to gather a petition to recall the board because they're failing to open a pickleball court. I know of a situation where, again, owners are screaming and yelling, and they broke into the clubhouse to have a happy hour. And the association, again, I had advised just let them do it. You can't stop that. But moving forward, it's education. That is the best of what the orders are, what they mean, why you are taking certain steps. I think the other thing I'm seeing a lot of, both nationally and locally, is, wanting to stop contracts you've already signed. You want to landscaper, don't come out. We don't need you right now. We don't want you to come out. And unless your contract has a force majeure type clause that says you can't come out, we can stop you, we can shut you down. You may be on the hook for that contract value because contractually they're required to come out. There's nothing in the contract that would prevent them from coming out. And there's also nothing in the contract seeing how, like I said, certain services were deemed essential, landscaping to the extent for minimal basis of, turning on irrigation systems, cutting grass, that was deemed essential in the state of Colorado. So they have a contractual right to come out. And it really does, even if you wanted to delay some of these projects, the contracts weren't set up that way. So I think moving forward, when you negotiate your contracts, and again, hindsight's 2020, if you can look back and say, okay, we're going to have a provision that says we can stop the work. We can stop this work during this period of whatever it be, natural disaster. This one is unfortunately, if you have a natural disaster, it comes and goes, like a hurricane, a storm, it's gone. And like a hailstorm in Colorado, it hits you for an hour and a half and then it's gone, and you come in, you enter cleanup mode. This one's not. This one, you are now in this delayed period that we don't know when it's going to open. We don't know when it's going to stop. Even though the state of Colorado Governor Polis has indicated he will lift the stay-at-home restrictions, it doesn't mean we're all back to order. And as they're saying, it's not flipping a switch. You still have this ramp-up period of time where certain businesses will be closed, restaurants will remain closed. You still have social distancing, and the intent is they want you still at home. So I think, again, building into these contracts the ability to stop them, building into your rules the ability to address certain things in advance, not reacting, as opposed to, like I said, being proactive in nature and looking at this and learning and moving forward.
Your question, your thoughts about staying at home, and all of us staying at home, is exactly what my next question's on. So with everyone sheltering in place, and we're hearing maybe a lot more of our neighbor than we've been hearing from them in the past, because they never leave, right? So we have these covenants that we're supposed to be enforcing, the managers, that is, and the boards. So how do we deal with this, with noise problems or compliance problems to the rules? What recourse does the association have when it relates to violations of COVID-19 protocols, for example? How do we enforce requirements of self-quarantine when people are traveling from a hot spot, let's say? These are all difficult things for us to manage right now.
These are all exceedingly difficult, if not impossible, things to manage. Because, Worth, that's a really good question. You've actually asked kind of two different questions. One being, everybody's at home. So things that in a normal course of action would not be annoying or would not be a violation are now being, owners are screaming nuisances. Most notably, if I go to work every day, I never hear my neighbor play their stereo. Or I had somebody come out and say, I go to work every day and I never smelled the fact that my neighbor smokes marijuana all day long. Now that I'm home, I hear it, I smell it, it's unbearable. And you as a board are getting these complaints, and you as managers are getting these complaints. And to some extent, you've got to ask yourself, one, is it really a violation? It may not be a violation. It may just be annoying behavior that, absent the fact that you're there and you have no outlet, you can't up and leave. You can't go to the store. You have to sit there and suffer under these problems. You have no ability to get at that. You've got to talk to your board and, again, educate your owners as to what really is a violation. And while smoking marijuana in a unit, there's nothing in your rules that stops it. You just can't address it. It's just, sorry, you're going to have to live with it. The second piece of your question actually, it was a three-part question. The second piece of your question, how do you enforce these rules? There's no stop on enforcement of covenants. Now, you can ask yourself, Well, if I am staying at home, how can I go out and enforce covenants? Uh, because I can't witness it, I can't see it. I, as a manager, can't go up and see the person doing whatever behavior that they are doing. And with that in mind, it's a lot of send the violation letter, but your violation letters may need to change a little bit, saying, dear owner, there's a potential violation, you know, you may be subject to a fine and the like. It's, dear owner, under these unique circumstances, we're really asking you to be conscientious of your neighbors and to make sure that you are taking every opportunity to comply with the covenants, and take that more of a, like I said, compassionate approach of recognizing you're all on top of each other. You can't go anywhere, and it makes it really difficult. You know, you are truly experiencing what close quarter living is, and you need to make sure that your owners are cognizant of that, and make sure your owners that know that, you know, once again, what may have been acceptable 3 weeks ago is no longer acceptable and won't be acceptable kind of moving forward during the pendency of these stay-at-homes. If it's actually a violation, send the violation letter, schedule the hearing remotely, schedule the hearing in the future, uh, to make sure it, but again, make sure your letters have a level of compassion in them, that, you know, we understand everybody's under a lot of stress, and it's probably best if you refrain from the behavior that you're experiencing. The final one is, how do you enforce stay-at-home orders or self-quarantine orders? You don't. Uh, you can't. It's one of those things that you're not the police. You can't lock people up. You can't go do rounds making sure everybody's in their cells. You have to make sure that, you know, again, to the extent possible, um, you are monitoring and, again, educating people. We did have one associate, or I have a client that called up and said somebody tested positive tested positive. They were not supposed to do anything. They were not supposed to leave their unit at all. They were supposed to have their food delivered, and they're out wandering around the community. In that particular case, the association spent quite a bit of money um, disinfecting the community, you know, brought a sanitation crew in and disinfected everything that that owner had touched and every place that owner had been. And looking at their declaration, you could make an argument that that person, through their negligent conduct, because they are required by state orders to stay inside, they were tested positive for COVID-19. They had admitted it, and therefore they negligently went around and contaminated the entirety of the community. That association is planning on assessing that cost of the disinfection back to that individual owner. I think that's, again, something that you want to make sure that you are educating your owners about first. Uh, I have talked with associations about, you know, that want to do renovations during this period, and they have contractors coming in. And this particular association is located in an area that it's a second home. It's in Summit County. Nobody is supposed to be there anyway. So again, they asked, can we charge the disinfectant, you charge these costs back to these owners that are having renovators come in, or having work done? And I again made it, don't know if they negligently, since they didn't test positive for COVID, but were coming in. I don't know if we had the ability to say that was negligent, but what we did do is said, you know, dear owner, there's nobody here to turn water off. There's nobody here to turn the electricity off if you need it to access these panels. So I think the association, you know, said, really tried to discourage the renovations, and that's actually someplace that I missed kind of talking about, you know, we talked about the renovations in your units with everybody home, and you've may having contractors come in. You may not be in a position to turn water off into some of these high-rise buildings, is because everybody needs it, and you can prohibit or prevent renovations to units to the extent that they need to shut off any utilities, to the extent that they need an elevator to bring items up. You can deny them that right to use that, or reserve that elevator, or deny them the right to turn the water off, because again, everybody's there, everybody's at home. You want to make sure that the common elements, the elevators, uh, the lobbies and the like, are available for everybody when they come in, and you can prohibit them from doing that. Again, and the other way of doing it is saying, you know, if you are out and you are not doing what you're supposed to be doing, any additional costs we incur because of your negligence will be billed back to you. Kind of trying to dissuade or disincentivize people from doing certain activities in the community.
Right, right. I know, gosh, we sure had the complaints with all the noise from rehabs going on. It's one thing when the building's a third full. It's totally different when it's 99% full.
Yeah, no,
And
absolutely.
someone's using a hammer. So, all right, the most recent recommendations from the CDC and requirements now in several cities and states is the use of masks in public places, even when social distancing. Um, should associations consider adopting that same policy in the common areas of the association?
In the common areas, absolutely. If there are certain, if they, again, using the CDC protocols of even just minor masks, you can set rules and establish rules for use of the common elements, much like you have a rule that says proper bathing attire must be used in the pool. Under these times, proper masking must be used while in the common elements, in the halls, in the elevator, in the lobby. You're not supposed to be within 6 feet of each other anyway, so you can absolutely, you can come up with a policy that says this. Now, with that being said, I'd want to make sure that everybody has the ability to get masks. I know there was a huge shortfall of even the cloth masks, and some owners may not be able to acquire a mask on short order. Now, I guarantee coming up to this fall, I guarantee people are going to be able to acquire masks. They're going to, go get them during the summer. But it's one of those things that, again, you may want to be able to remind, educate, educate, educate. And if the association were to use common expenses to go out and get masks for everybody's use moving into this, so there will be no excuse that I can't get a mask. It's, oh, here's one. And the association has a minor stockpile of them when they're going to go on sale this summer. It would not necessarily be a bad idea.
Right. Okay. Great. Well, a follow-up to that, can communities enforce social distancing?
That's a lot harder to enforce social distancing. I don't want the association management or the board to go out and start accosting people saying you're too close, you're too close. Here's the rule, or here's 6 feet. In the stores, they've got everybody kind of lined up with the little X's as to where they can be. I don't want to put you in that position. But can you, again, educate, make these strong recommendations? Can you close picnic tables that are in the community that encourage gatherings? Yeah, the state said do it. The state said if any place encourages a gathering of people, close it. And you have that ability to close it. And that way it's not enforcing social distancing as opposed to you're using a common element when you're not supposed to be using it.
Okay. All right. How about real estate? Having open houses, having showings, just taking a potential buyer in. I mean,
it's up until the 27th, the state of Colorado is prohibiting showings and prohibiting open houses. So if you see that is by definition a violation of the stay-at-home order. It's also a violation, and you can shut that behavior down. Come the 27th, you're going to have to make those decisions. While open houses are still prohibited, showing a unit is not. So I think if you're going to have people start to come in until this loosens up, well, actually, I take that back. In the city and county of Denver, if your community's in the city and county of Denver, your stay-at-home order is extended until April 30th anyway. So starting May 1, can you start to have showings? Yes, you can start to have showings. What I would do is potentially adopt a rule, have the board adopt a rule as to when those showings may occur. You've still got a lot of people in the units. You've still got a lot of people in your community because the stay-at-home order just didn't go away. Governor Polis calls it the safer at home order. So you're still going to have a lot of people coming in, maybe set times that showings can occur. Showings can occur between 10 and 11. We're going to open the elevator up, let all your owners know that the elevator is going to be open up for showings. So you don't, if you want to stay out of the elevator, you can stay out of the elevator. You can potentially have masks, like I said, ready, or hopefully the realtors have masks ready when they come into your community so they can put on, if you've got a rule that says you have to wear a mask in the community, they let everybody know that masks are required in the community. Masks are required in the common elements. Don't even come in if you don't have it, and you set the hours when they come in. I think those are all reasonable restrictions to apply to this very unique situation that we find ourselves in.
Excellent, excellent. All right, now we have some of our guests have submitted some questions. So Jason, would you read a question or two for us?
Gladly. So the last question that I got pertains to what you were just speaking of. So on the topic of masks in common areas, is it enforceable with a violation, or is it something that's going to be a little bit more strict due to the nature of this being a safety concern?
It's realistically speaking, if your policy says, and again, this is part of the existing policy that I don't want you to deviate from, is you send a warning letter and they have 10 days to come into compliance, and then you send the second. It's you do some policies will have habitual offender or other exclusions or carve outs, but you need to stay within your policy. That's where it really gets to. Even the city of Denver isn't issuing tickets for the social distancing and the failure to have masks. They call it their education campaign, not fine campaign. And I think it is going to be, again, from your points of view, at least this go round at this point, now that we're kind of hopefully getting towards the end of easing of some of these restrictions of, dear owner, remember, we have a mask requirement. It's for a reason. Our buildings, many buildings contain people that are very at risk. They shouldn't, you're saving their lives, if you will. And we want to make sure that everybody knows that these masks are being provided, or the mask requirement is really not to save yourself, because it's doing very little for yourself. It's to prevent disease from spreading to your neighbors. And I think keep that up. And then, again, coming in, if we continue down this path, maybe you start to drop the fine hammer at a later date. But really, it's education, education, education at this point.
There's a question that's tangential to that, and it's from David, who asks, from a legal perspective, how can association legally manage the fact that COVID-19 positive persons, they may be positive, but at a later point they may be negative and then come back as positive? So how do we manage that, and especially in the fact that we may have waves of this?
And that's was kind of getting to, the association doesn't. And the association, one may or may not have any knowledge that a person tests positive, if they even test. It's the state of Colorado is, by all indications, very far behind in their testing. And the last number I saw is it estimated between 40 and 50% of people in the state of Colorado have had or will have COVID-19 before it's all said and done. So, you walking around, you may not even know you had it. You may be asymptomatic. So it's one of those things that you really can't. So the legal duties of the association are to protect, the common elements, not to protect people movement, protect the common elements, adopt reasonable rules and regulations, like I said, regarding, when people can come in to show houses, when renovations cannot be undertaken, and try and encourage people to wear masks if they're not. Maybe you adopt a much more harsh rule, but then it's education, education, education. You can't control people. And that's the one thing, and we've seen in the United States of America, which is why we have more cases than any other country, is because I will say the leanings of the United States, or the people in the America that we can't be told what to do, and we're going to go do what we want to do. It's just something we do. And that's why even under this pandemic, you still see people walking out at Sloan's Lake. You still see people walking out on the streets. They're wearing masks. They're not wearing masks. They are very unimpressed with the virus, if you will.
I think that leads to looking at that same question from a different perspective. So you talked about it from the association's perspective and what their obligations are, but what about a person who tests positive? Are they obligated to inform the community that they live in, or can they remain anonymous?
They can remain anonymous. There is some laxing of the HIPAA requirements for doctors disclosing certain information to the CDC, to certain other people. But as far as my obligation to come in and tell you if I have COVID-19, I have no obligation. I can if I want. I probably should. But if I'm going to come in, and if I'm going to, under the dark of night, go up into my unit and never leave, I have no obligation to tell you. And it is you, as an association, I would not recommend you tell people that the owner of unit 302 has COVID-19. It creates a stigma. There was news stories coming out of people testing positive and then they being harassed in the community. So that's why again, the whole point of not having to tell if you have a particular disease or keep your medical records confidential was to prevent those type of stigmas. So the association has no obligation to tell. Well, the owner has no obligation to tell the association. The association should tread very carefully in trying to identify somebody that has COVID-19 without express permission of that owner. If they know that somebody has tested positive, they can, again, educate the community. I had been recommending communications of dear owners. We have no doubt as this disease continues to spread and it's going to impact X number of people, it will touch this community. We ask that you take all precautions necessary. Heed the CDC advice. Wear masks, stay in place, don't come out unless you have to. And then the association, explain what the association has done to minimize the impact. We are disinfecting the common elements every other day. We are disinfecting the lobby on a third day basis. The elevators is done daily. Kind of explain what you've done and the reasoning, and that way owners will understand that, one, you are taking it seriously, two, they need to take it seriously as well. And there is risk of going out, because if they go through the lobby on a day that it wasn't sanitized and somebody came walking in, there's still that risk. But again, we were talking about what you do with your budgets. This is something that renders your budget, you'll blow your budget in common element cleaning inside of 24 hours, trying to stay ahead of disinfecting this.
Well, there was a question that started relating to the budget's perspective that says, you mentioned a competitive interest rate, and if you're borrowing from your reserve to fund an operational shortfall. Just expand a little bit on that concept.
Of course.
What would it look like in terms of rate and term?
It's rate and terms, not so much term. You can obviously, if you were to go out and get a loan from a bank, an association loan from a bank, the interest rates are running 4.5%, 5%, but you're paying that to a corporate lender. Your term will never have a prepayment penalty. So if you are going to borrow from one fund to the other, we have advised that you adopt a resolution saying why you're doing it, what it's going to be used for, and then actually sign a promissory note from the reserve account to the operating account. And it needs to look like an arm's length transaction. So if your money is earning 0.8% in a CD or 0.8% in a savings account, pay yourself that 0.8, pay yourself 1%. And then as you pay it back, you can show that the reserves will be in a better position when it's done than they were otherwise, because you paid it a little bit higher interest rate, but at least pay what it was earning. I think that's going to be kind of the general baseline of, if you pay anything less than what it was earning, it becomes a non-arm's length transaction.
Excellent, thank you. So this question really pertains to almost everything that we've talked about today. And this pandemic has caught boards and HOAs unprepared or just not ready to face a scenario like this through their bylaws, rules, and regulations. Do you advise reviewing and revising all of those, based on what we've learned here throughout the duration of the pandemic?
I always say we can learn from the past. And do we think the question becomes, is this going to happen again? Do we need to go through the drill of addressing something that is kind of a 1 in 1,000-year storm? Unfortunately, every indication is, yeah, it's going to happen again. It's probably going to happen in December. And that way, putting together your policies, and we talked about the fine structure and a rule to require masks. You have a policy regarding adoption of policies. In the state of Colorado, you have to go through whatever that policy says, you have to go through it. So if you're going to adopt a policy regarding adoption, or if you're going to adopt a policy that everybody wears masks and your policy says you have to submit it to the owners for 30 days for comment, and you can come back and adopt it, you've lost 30 days. So I think trying to look at something and maybe amending your policies to allow emergency rule production. Fines on the first offense is not common in policies. Now, I've got a lot of associations that do, or we represent a lot of communities that do have fines on the first offense. You still have to provide notice and an opportunity for a hearing, but you can fine on that first offense. You don't have to send a warning letter. So maybe you go down that path of, we're going to go ahead and we're going to remove the warning letter, and it's going to fine on the first offense, and we're going to have expedited hearings by Skype. Hearings within 24 hours. And if the owner fails to attend, you can go ahead and you can fine. So you can start tweaking some of these things. But again, I don't want to go so far, the pendulum to swing so far that you fail to recognize that this is stressful on everybody, and everybody is going through this, and everybody has this problem, and they may have lost their job, they may be unemployed, they may be furloughed, heaven forbid they worked in a restaurant. I had heard experts come out and say that when we come out of this, less than 1 in 5 restaurants are going to reopen. And if that is in fact the case, you've got a lot of people that are now out of work, and a lot of restaurant owners that are now out of work, and you need to have that. This wasn't their fault either, and it's not like they wanted to go out and do this. So I think we need to look at what worked and what didn't work and address that accordingly. Like I said, we started the conversation with, there are associations that the owners are absolutely incensed that the amenities were closed. The pool didn't open, or the gym closed, the workout facility closed, you wouldn't open it up. And I think having that understanding in place beforehand will allow owners to accept it more readily if you have to do it again.
Worth, you've got years of experience in the same capacity. Do you have any either insights or questions that you'd add to that?
Well, I have a question that was just emailed me, and this pertains to an association, not in Colorado, actually, it's here in Texas. But a board member just sent me a question saying, hey, I know that a family member is going to go pick up someone who is tested positive and bring them back to recuperate in our association. Is there anything our board can do to stop someone that we know in advance who's positive coming into the association? I imagine that applies in Colorado, just like Texas.
It would apply in Colorado, and I would argue, no, there's nothing you can do. One, an owner has an absolute right to use their unit. Two, they have an absolute right to invite guests into their unit. The declaration probably there says owners, their guests and invitees, owners, tenants, guests and invitees. It also, if they are sick, that is a disease. So if you try and preclude them from the community, it becomes an FHA violation based on discrimination. You're discriminating against this particular person. I think the best way to address it would be that same way of, dear owner, if you bring this person in, we're going to disinfect the common elements. We'll kind of give you this one freebie because you are allowed to do it. But if they come out of the unit, if they're seen in the area at all during the pendency of this issue, we're going to charge you for the second disinfectant because that's negligent. With COVID, you are required to stay in place. Now, in Texas, the stay-at-home orders may be a little bit different. I mean, every stay-at-home order in the state of Colorado is different for every county. So you've got to look at the particular stay-at-home order under this particular thing and then determine, is that negligent, and do we have the right to assess some of these costs back if we have to go in and spend $1,000 to clean the elevators, clean the lobby, disinfect it to prevent the spread of this disease, and to some extent, quite frankly, to alleviate the fears of the owners in the community, because that fear is going to rise. And you need to make sure that you communicate with that person, but also with the community as general. Again, to that message of, we have no doubt it's going to impact us. This is what we're doing. Please don't mess it up.
Right. So, David, there are some questions that are following that specific
Mhm.
line of thought that says, one was an observation that in the recent weeks, many cities have started placing enhanced restrictions or outright, they've started increasing requests to reopen amenity spaces, such as a gym or a pool or a conference room. From a legal perspective, do you have concerns with boards exercising their own business judgment and keeping amenities closed through the duration of the pandemic or outside of the guidelines?
No, I have no problem with the association exercising its sound decision making based on advice of professionals for acting one way or the other. And I say that because, yes, there is a large drumbeat to reopen the amenities. And I was talking with an association where we had talked about, all right, if you're one, got to find out if you can even open it. It's like I said, right now in the state of Colorado, up until the 27th, 30th in Denver, you cannot even open a rec facility, a gym, a pool. That's just, you can't. When that rolls off, can the association, to your point, keep them closed? Well, I would argue yes. The association has an absolute right to open or close common elements. I would ask that the association uh, adopt a resolution saying, including findings, not just, we're going to keep it closed. It's adopt some findings, adopt it. Whereas because COVID-19 did this, and if you've read the state's stay-at-home orders, they kind of go through that. COVID-19 is highly transmittable. COVID-19 is highly contagious. It has this, the state has issued a stay-at-home order, and then find one of the many expert opinions that you would like to rely on, throw it in the meeting minutes. Or throw it in the resolution as to why you are acting in a certain way, either opening it and saying, that there's enough out there to say you can open, you have to, encourage social distancing. If you've got a clubhouse that is appropriately sized for 20 people, we're capping it at 10. And why? Well, because the state of Colorado said we have to have 50% social distancing. Go through that drill, and that way it'll help form the decision. And that way, in the event somebody does come back and tries to sue saying, you opened it and I got sick, well, you can sit there and point, well, we opened it because of X, Y, and Z. We have all this information. We made a business judgment decision. We required no more than half capacity. We required reservations so we knew who was in the gym at what time. We know who was at the pool at what time. We gave them 1 hour to sit in the pool and then they had to leave. We provided hand sanitizer going in, and we provided sanitation equipment, so they could wipe their seat down when they got there, and they could wipe it down when they left, and put that in your rules. And then the owner comes, whoever that next shift comes in to use the pool can wipe the chair down, and there are only 10 people in the pool. You adopted all these rules, you adopted all these findings, and you show why you acted a certain way. As long as it's based on fact and reality, it's perfectly acceptable. If on the flip side, the association wants to keep it closed, same thing. Go through it because it's highly contagious. It's this. We don't have the financial wherewithal to keep cleaning. We don't have to do this. Therefore, we're just shutting it down until June 1st or whatever date you choose. Just make sure that you are, again, documenting it, and you can rely on the business judgment rule. So that way, if somebody does come back and sues, the association can pull out the resolution, say, this is why we acted in this way, and there will be no liability to the association. There's no liability to the director. And I would have a hard time believing any court would find any liability either way.
Right. There was a comment that talks about using tapering as a strategy for reopening, and things like restricting the use of a pool to no more than 3 at a time, or so there's lots of options that boards can exercise in this.
There are, and I think that's probably the best way to go, is just, again, first come, first serve. You can't reserve more than 3 times a week or more than twice a week. Here's the calendar. It's going to be a pain for you. The manager's paying for you. The boards try and implement it. And that may be, again, why you decide to keep it closed, is you just don't have the financial wherewithal or don't have the ability to regulate this pool. But if you do, and you decide to open it, yes, you can sit there and, like I said, everybody can get an hour. They can't sit there and occupy the whole time. You got to go in, you got to go out, you got to wipe it down. You got to, when you get there, got to wipe it down when you leave and get out.
Excellent. Let's see, I have two more questions. One is a logistic question, which I'll save to the very end because I want everybody to be able to hear it. And then we've got a question about specifically short-term rentals, and that cities have started placing enhanced restrictions on ban or just outright ban of short-term rentals in an effort to minimize the spread. And it says that these restrictions are coming with some exceptions and do not prohibit short-term rentals for people like hospital employees or other licensed healthcare professionals, military professionals, law enforcement, things like that. Should associations give consideration to permitting short-term rental activity for these types of exemptions? What would you suggest the managers do to effectively manage the potential increase for demand?
I think if you're going to allow that, and I think it's a wonderful idea, solicit volunteers, if you will, from your ownership group of dear owners, if you want to open your unit to this type of use, please let us know. So again, we can facilitate it. We can either let the appropriate people know that we have a unit that is willing to be rented on a short-term transient basis, and we can also put in rules as to where this particular owner, or where this particular person coming in can go and when they can go. Remember, if it's for medical personnel, doctors, nurses, and the like, they're not going home because they don't want to bring it into their house. So bringing it in, quite frankly, to your house, unfortunately. And I think they are more than willing to accept certain restrictions. Only come in through the side door. When you come in, please just give us a call and we'll go on, we'll wipe it down after you leave it to make sure, again, you're not impacting our community, because they don't want to impact your community any more than they want to impact their home. I think it's a wonderful plan. I don't know if anybody saw the story that went around last week. An association back in New Jersey, one of the owners had made their RV available to the doctors. They took it home, took it to the doctor's house. The doctor could just go home. They could park there in their driveway. They could see their family. They could have a virtual dinner. And the association came down and fined the family, saying, get rid of the RV. So it's one of those things where you also need to, like I said, look at what you're trying to do and see if there's a way around what you're trying to do, and see if there's a workaround. You may have a complete total ban on RVs. Well, City of Fort Collins said, no, nice try. RVs are now, whether your declaration prohibits them or not, they're allowed in your community because we want doctors to be able to stay home near their families, and this is the best way to do it. So I think those type of programs can come with some strings. They can also come, if they are well implemented, you can absolutely make it available to owners, regardless of what your declaration says. Because again, I don't think a court will hear the case if somebody does try and challenge it. But at the same time, work with the owner, work with the occupant to allow you to reasonably facilitate this action and minimize the risk to both the doctor, or I say doctor, but the person using it, as well as the community as a whole.
Excellent. And Tony had a comment on that, and he said Denver has a process and restrictions in place for owners that they must meet before they can use Airbnb, for example.
Yeah.
So excellent. Well, I don't see any more questions in the question box. Worth, do you have anything you want to add? Or
I have one question left on my side. So a board member said our association has always had valet parking, but now we're doing away with it, and people are saying it's an essential service that we're supposed to provide. Is that true?
Again, that would be depending on the particular stay-at-home order. No, I don't think an essential service is parking somebody's car. There may be certain reasons that it's deemed an essential service, in that it's an age-restricted community, and you have a large percent of the population that's ambulatory, or, well, they wouldn't be driving. I can't see it as an essential service. I'm sorry. But there could be a reason, but it would also be
I think that's what that board member wanted to hear.
stay at home based it would be particularly your stay-at-home order. And I have not seen where valet service is an essential service on any stay-at-home order. I could see, like I said, somebody arguing and saying, I can't, I need this, but there are other fixes to that. Since nobody's supposed to be driving anybody, if they come in and you could give them a guest parking space right up front, they can walk in. It would be a case-by-case basis.
Great. All right.
I've got one question that just came in, and it says, recent news reports say that air conditioning units, potentially common air conditioning units, could carry COVID. Would there be any legal ramifications to the HOAs?
As long as the HOA is maintaining their common elements in accordance with their design standard, the association's not going to be liable. Now, I'm sure that, again, if you're in a high rise and you've got central air and you've got, ducted heating and venting, you may want to be a little bit more cautious about it. You may want to make sure that, again, if you can go in and clean it, do it a little bit more often. But again, that's a budgetary concern. That cannot be cheap, going in and cleaning a 16, 18, 20-story building's ventilation system on the inside. So there's not going to be any liability to the association, but it's one of those things that, again, you need to be cognizant of it. And maybe coming out of this, you go ahead and clean it.
Excellent. Well, I think we're out of questions and we are almost out of time. So first and foremost, I'd like to say thank you to both of you. I can't believe it was 55 minutes. It just went by in a flash. And David, I want to thank you for your insight and your expertise. And it is very clear why HOA and association communities across Colorado have leveraged your service in times of need. And Worth, thank you for your insight as well. And thank you for framing the questions in a way that it really brings and illuminates what's top of mind to all of us who are in these communities and manage these communities. So I want to say thank you to both of you, and thank you all for everyone who attended. There will be there is a recording of this, and we will send a link to all the board members and make sure that you have access to this as well as any other webinars that we bring out that are in response to this particular pandemic, as well as general informational webinars in this series. So with that, this is Jason Mitchell signing off. Thank you all very much. Have a great night.
Right. Thank you very much. Thank you, and stay safe.
Thank you.
Thank you. You too.
Thanks.